Hey there, legal warriors. In this video, I'm going to cover the three-step process that might help you be able to get a good result in your criminal case. Typically, the client has 3 steps. The attorney might have 3 similar steps. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged all throughout Washington State for more than 25 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now I'm just going to jump right into it. Criminal defense cases. There are different theories about how you defend a criminal charge all throughout the country, but for this channel in Washington State. And there are different ways to do it. Now, for the most part, people out there in the public, I think it's all about the facts. It's all about the fact pattern. It's all about what happened. And in certain cases, that's true. In certain cases, what happened matters more than you would think because sometimes the police get it wrong. But the dirty little secret of the criminal defense industry is oftentimes the police get it generally right? They have an admission from the suspect who admits they pushed or shoved their loved one, or they have a breath test that's significantly over the limit and someone's weaving all over the road, or they got the video of the person stealing something, leaving from Nordstrom. And so we can't really use the fact pattern there to defend the case. Just take it to trial, call the right witnesses. Well, oftentimes the evidence is not able to be overcome by a factual attack on the case. And, the sad part is public defenders are really good, but oftentimes their main and only approach is to take a factual-based approach. And when the report has solid facts that can't be debated, well, then you're pretty much stuck if that's the only way you do it. So what is a 3-step process that can be used in those cases where we have really bad facts that can't be disproved? Well, there's 3 steps. 3 steps a client has is what we tell our clients. Step 1 is patience. You got to realize the case is going to take some time, and if the facts are really bad against you, then more time is better. Why is that? More time is better because there's more time to show that you're not a big risk. You got more lawful behavior. Witnesses that exist against you as time passes, their memory's not going to get better. They might move. They might get into their own problems. And also, as the case gets older, there's more pressure on the prosecutor to do something to get rid of the case because while there might be bad facts and it might be an easy case for a prosecutor to win at trial, they don't have time to take all the cases to trial. So step 1 is patience. Step 2 is in this theory of how things can be done is the client needs to do something. The client needs to do something so the prosecutor can feel part of the solution. It's not the prosecutor's job to let us go. It's the prosecutor's job to respond to the case in some way. And if a client does no affirmative actions, classes, education, something like that, you really only give the prosecutor's ego one way to respond. Go for the throat, Try to really do bad things because nothing else has happened, and it's not my job as a prosecutor to let people go. And then step 3 for clients is typically no new problems. The only person who gets to talk to a client, to the defendant in the case, is the defendant's attorney. And so that might be the public defender, might be your private attorney. And so we as attorneys are the ones sort of vouching for what a good person our client is, what an unusual situation it is for the client. And it's really important that as time passes, you don't get into new problems so it doesn't cut our feet out from underneath us. And the corollary to that is if you have a new problem, typically you don't want to be embarrassed or keep it from your attorney by not telling your attorney because the attorney should not be put in a situation to say, what a great client of mine, and you should let them go for this. And then the prosecutor looks over at you and says, well, what about the new DUI they just got? Did they tell you about that? That's happened to me. And what I have to do, I had to turn around and walk away. And that wasn't a very successful negotiation that day. Now, it might be able to be saved in a big firm. We can, have a different voice come in for that situation. But it's why it's important that you don't hide things from your attorney. Because if it looks like they have really good facts against you, the prosecutor, our main way out of this situation is this method. Now, Typically, the defense attorney has a similar pattern, right? We're not going to negotiate super early. There's going to be some delay, and that's maybe so you can get done step 2. We're going to figure out what it is you need to do, what type of classes, what type of evaluation, what's going to be effective for the very court you're in, with the very judge you have, with the very prosecutor you have, with the specific charge you have. Lawyer Google does not know. They do not know that on one side of the street is this court where X is effective, on the other side of the street is a different court where Y is effective in the same exact case, but each court may want something else. That's why you have to trust your attorney. Then step 3 typically is, how do we talk to the particular prosecutor in your case? What do we know? Are they better in person? Are they more, available executive function to talk to us in person? Are they the types that will respond to an email, or does email just go into the black hole, never to be heard again? Will they pick up the phone? Are we likely to see them in court? Those are the things that your attorney has to consider when we're talking about a case that can be negotiated, that's a non-felony, that has bad facts, where we don't want to go into the facts too much. Now, if we also have a factual defense, even better. Then step 3, when we're talking to the prosecutor, remember, it gets delayed, we get you to do some stuff, and then step 3, now we can whisper the facts to the prosecutor, and they're more receptive to hearing them because we're providing them a solution to their case that makes sense for them while pointing out the problems with their case. Now, typically, these methods aren't going to work for major felonies, very serious crimes. That's almost all fact-based. Not exclusively. Still, classes and things can help if you get a prosecutor near the edge on the facts and they see that you've done something good where now they can save some face on their own and have a justification for seeing the fact pattern your way. That's a good idea. So remember, if your attorney needs you to do something for that step 2, some classes and things like that, it's not necessarily because you need it. It's because your case needs it. And if an attorney isn't doing these things on a misdemeanor level case and they're only taking a factual approach, I think they're messing up. They're messing up because remember, if we're doing classes and stuff like that, the fact that you're doing things like that cannot be used against you in court. It's not a sign of guilt, any of that stuff. It simply cannot be used. It's basically under offers of settlement, that type of thing. The prosecutor can't come and say, well, you did some anger management, didn't you? So therefore you must have an anger problem, right, jury? They can't introduce that. That's not allowed in evidence. So the reason I'm putting this out is just so you can understand that the different ways of doing things. And typically speaking, in criminal matters, just going straight at the facts alone is just stupid. You can definitely go at the facts, and we need to point out all the facts that are wrong, but we need to do the other steps also so we can control the outcome. We want the best possible outcome with the least amount of risk because, the jury's not going to find me guilty. Remember, you're at a jury trial, you're sitting in the guilty seat, not the not guilty seat, and everything is rigged in favor of the state. Oftentimes, court rulings are looking at precedent, and all precedent case law is generally in the favor of the state. There's no one lobbying for people accused of crimes out there. So we want to do everything we can to get the best result with the least risk possible. And that goes for any attorney, hopefully, that's doing really high-level defense work in Washington State. So I hope you found this useful. If so, please like it, please subscribe. More people get to see it. More people get the help they need. More importantly, if you got a criminal matter, Washington State, feel free to reach out to my firm. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.